Welcome to Hull Estates and Succession Planning, a series of podcasts hosted by Ian Hull and Suzana popovic-montag. The podcast you are listening to will provide information and insights into estate planning in Canada. From the offices of Hull and Hull in Toronto, here are Ian and Suzana.
Hi, and welcome to Hull Estate and Succession Planning. You're listening to episode 165 of our podcast on Tuesday, May 19th, 2009.
Hi, Suzana.
Hi there, Ian. How are you today?
Terrific, thanks.
That's good.
All right, we're where the buck stops here in that series of our podcasts, in the sense that what's it really going to cost you financially? We spend a lot of time talking about some of the emotional strains that come from litigation, and we have on Hull Estate Mediation webpage, we have a brochure that sort of sets out what we call the estimated cost of it. So we're going to spend some more time talking about the estimated costs. We started our last podcast talking about this wide discretion the court has, and we finished it with talking about what kind of ranges are we looking at. So we've had the first meeting, we've started to do a little bit of exploration, we're going to, what we call, do an order for directions, which is a motion, and that's like our statement of claim. And that first stage involves meeting with the client, reading documents, and typically preparing for and attending at court, which again, hourly rates can vary, but you're looking at anywhere between sort of 15 hours of lawyer's time minimum to 30, 40 hours of lawyer's time, depending how contentious it gets.
That's right.
So we'll have got to the point, and let's just sort of break this down. Phase one or stage one is client comes to see you to court order, and that is the first preliminary order for directions. And as we've talked about in the past, there's really actually nothing that's directly accomplished here except for information gathering.
Right.
And we're only information gathering as far as we can legally.
Yes. Because
the order for directions opens the door to get the next stage. And let's talk about then what's our next stage. So stage one is get us from first meeting to order for directions, and we estimate, in our booklet, we estimate anywhere between, I've talked about the hours, but you're probably looking at anywhere between $5,000 to $20,000 of lawyer's time. And it's flexible and depending on where you are.
And one of the things that I say to my clients is that, when you talk about costs, the only thing I can guarantee is my side of the equation. And if you've got very contentious, difficult counsel on the other side, a matter that should only cost $5,000 can cost $15,000, not because of anything that you've done improperly, but because of the fact that you've got to respond to the individual who's making it difficult for you. And that's one of the things that's the hardest to predict. The costs are hard enough to predict from our end, but when you're dealing with that unknown in terms of how you'll have to respond to the other side, it makes it very difficult to anticipate it.
It's so true. You cannot control the other side's behavior. And if the other side behaves in a way that costs you money, it costs you money.
Yeah.
And unless you want to throw in the towel at that preliminary stage one, you have to belly up to the bar, as they say.
Yeah. And then the next stage, Ian, after we've done that preliminary court attendance and received the authorization and the ability to go in to collect additional documentation outside of the legal parameters that you talked about initially that we would have, we're looking at getting perhaps the medical records, getting the financial records, getting the solicitor's notes, and so further evidence gathering essentially.
And really, you've described this as it's intense. This is the intense investigation. We are going to get these third-party sources of information to support, and we kept coming back to our initial sort of scenario, and that is a will challenge, where the brother was tired of getting nothing under the estate, got nothing from parents when they're alive, and feels, misdealt a card in terms of the estate because he got written out of the will. So he's challenging the will. The first stage allows him to just be able to get the preliminary story on the table, and then the second stage, which is this stage, is a big part of the intense third-party documentary investigation. And that can take, again, you're looking at, depending on lawyer's time, clerk's time, and so forth, you're looking at many, many hours of effort. And that, from that standpoint, your book describes it as somewhere between, even guesstimating $5,000 to $60,000. It seems like a strange spread, but like you say, it depends on behavior, depends on what documentation you're going to have to chase, and so forth. So you're looking at big dollars, even at stage two.
For sure. And then once you finish that stage, you move on to possibly considering the attendance at a mediation or possibly proceeding to discoveries. And certain jurisdictions will do that in different orders. Certain practitioners will choose to do that one as opposed to the other at stage 3. But I know we would typically move to mediation if we can, if it's the right time in the lawsuit and if it seems to be something that is facilitated and amenable to the other side. Now, some jurisdictions actually have mandatory mediation and others don't, but I think in any event, it's something that people would be well suited to consider after they've done that intensive investigation and built their case or learned their case as best as they can.
And so again, we're looking at many hours of time and effort by lawyers and clerks and so forth, and you're looking at the cost of the mediator himself or herself. So again, your book says estimate $10,000 to $50,000, and estimates, again, wide ranges, but will depend on the complexity of the case, the behavior of the individuals, and so forth.
That's
All right, so now we're really, the cash register is ringing off the hook.
That's for sure.
And you can see that we haven't really got that far along in the lawsuit, and we're into the tens of thousands of dollars. Depending on the case, there's obviously lots of war stories or horror stories that we could tell where even this kind of money was way too low. But there's also, there are cases where we move pretty quickly and efficiently to get to mediation, get the information that, accessible on a non-contentious and also on a modestly cost basis. But good to have the ranges and good to know that we could have spent by now, just on our rough estimates, we could have already spent over $100,000.
For sure.
All right, and that's just on your side, our side.
Exactly.
In that sense. Okay, so the next stage, you said that you could choose to go to mediation or discoveries, and we've talked about discoveries, and we may talk a bit more about that process, but that's really the time where, on the record, with a transcription of everything you say, you get to explain your case away, and vice versa, with lawyers around and all of that stuff. Tell me about that kind of cost estimates there.
Well, those costs, Ian, they could range anywhere from $15,000 up to maybe $50,000, $60,000, depending on how many people are involved, how many lawyers are involved as well. I mean, there could be several lawyers, or there could be one lawyer representing a group of individuals.
Right.
There's so many unknowns in that whole process and how it could unfold that it's kind of hard to peg it, but discoveries tend to be much more expensive than people would expect them to be because of the nature of the process.
It's days of preparation, days of organizing documents, and days of sitting in a room asking questions.
Yes.
And it can be, quite frankly, can be overwhelming in terms of the cost. All right.
There's also, of course, the motions that can arise as a result of the discoveries of refusals to answer questions or to provide undertakings. And that, again, can't really predict which case that'll arise in, but it is a possibility that just adds to the costs.
For sure. What about interim motions? And first of all, what do I mean by saying that? And second of all, what kind of costs can we be looking at for that?
Well, just the clearest example is a motion for undertakings or a motion to compel answers to refusals. I think that's one of the motions that can arise at this stage. It may be that at this point in time, depending on the nature of the evidence that's been provided or the way that the conduct of the parties, there might be some relief that you would seek a judge to provide to you in order to be able to continue to build with your case.
And one of the things you struggle with, again, on that, and we'll just wind up our thoughts about that at this point, because is the whole question of motions. And so why don't we do our next podcast coming into that issue of the different kinds of motions that could occur, and illustrate the kinds of exploding costs you can get into when it looked like a perfectly normal, simple case at the start.
Great, Ian. I look forward to that podcast.
Thanks a lot. Me too.
Thank you.
You have been listening to Hull on Estate and Succession Planning by Ian Hull and Suzana popovic-montag. The podcast you have been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you are reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull & Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.